All right, thank you, Olabode Arawa, for that background report on the Justice Sector Summit. Well, fortunately, Kiran and I are not legal practitioners, so we are in a better state to ask all the questions, of course, that you would want to ask. But don't forget, we have our Twitter handle at NTA GMN, so you can also be part of our conversation this morning. Quickly, let me introduce the guests who are already right here in the studio. We have with us Chairman, NBA Judiciary Committee, Dr. Babatunde Ajibade, Senior Advocate of Nigeria, and Leonard Sick. Thank you for joining us.
Thank you. Thank you for having me.
Also in the studio here with us is a member, Justice Reform Project, Mr. Osaro Hubamir, Senior Advocate of Nigeria. Leonard Sick, thank you for joining us on the program.
Thank you very much and good morning. Thank you.
All right. In addition to the learned gentleman here with us in the studio, we have a country representative of the UN Office on Drug and Crime. That's Mr. Oliver Stope. I hope I got that correctly. All right.
Very much so. Thank you very much.
You're welcome. And another legal practitioner here in our studio is Shaba Ibrahim. Shaba Ibrahim is member of the House of Representatives and former chairman, NBA Lokoja branch. Thank you for being part of our program this morning.
Good morning, Nigerians. It's my pleasure to be here.
Okay. All right, gentlemen, I mean, the issue here is very critical, you know, because when you talk about the justice, judicial sector, of course, it's where the common man relies, especially when there are very, critical issues in contention in courts. But over the years, we've heard about justice reform in this country. And just yesterday, we just had a launch, which is another leg of reform, which has just kick-started. So let me just ask you, Mr. Osaro Homabian, why do we need reform in this sector in the country? What has been, the burning issues that has led to where we are today in the Nigeria's judicial system?
Thank you very much. Let me start like this. For you to administer justice, you need the confidence of those who use the service. Law is not just about the rules to resolve disputes, but I think you have to see law as a set of values upon which important parts of our society is predicated. So we've got to the point where we realize that there's a lack of confidence by those who use the process, and then there's an absence of constant review. As I always say, with law and the administration of justice, one needs to attend to it constantly. What we do in the administration of justice and why we do it must be subject to constant review. Unfortunately, perhaps, the institutions that are created or that were created for this constant review are either weak or in some cases have not performed effectively. So you have these interventions. Now, for the first time, you now have the NBA leading a group of other collaborators. And I think I need to mention the name because a lot of work went into this. In particular, the Justice Research Institute that I worked with, and we've all come together to say, what do we need to do about the maladministration of justice, the fact that there is no confidence in the system. I use this opportunity to thank those who worked in the Justice Research Institute, because yesterday, when we finished, I didn't have the opportunity to single them out. Dr. Balkisu, Adiza, and Mutiu. We all work together. Now, I am interested in reforms, just like every lawyer should do. I always say that every lawyer should know what is wrong with the law, should predict change, and should participate in that change. So what I've been doing is personally running a 42-kilometer mile every year, just to bring attention to the issues. And that this summit is a product of what we've done. I've been speaking to Dr. Ajibade, who will talk to the issues shortly, speaking to Oliver as well, and of course Dr. Balkisu. And then we came together to say what is what is wrong with the system. But the difference with this summit is that we did not focus on just discussion, we are focused on implementation. So a few resolutions came out yesterday, and I think...
Just before you go, hold it, Leonard, just before you go to your recommendations, I think we need to look more closely to the points that you have raised, because I have this feeling that you've just only scratched, the surface of Kiran's question to you. And that's why I want to escalate it and bring in the chairman of the NBA Judiciary Committee, Dr. Babatunde Ajibade. And I'm going to phrase my question around Dr. Martin Luther King Jr.'s words. And he says, law and order, and I want you to, answer us. Have our law and order become dangerously structured dams? That's how he puts it. Such that they block the flow of social progress. Have our law and order, given the response of the senior advocate Ehubamia, that we have lack of confidence, there's absence of constant review, and the institutions to even perform the review are themselves weak. So would you say that our law and order have failed to serve the purpose of the social contract?
I think to a large degree that is correct, and I think that is the motivation for what we are trying to do. I don't think any honest assessment of the Nigerian justice sector would not conclude that there has been a consistent decline in the capacity of the justice sector to meet the yearnings of society. And as Mr. Ehubame has said, really systems don't fix themselves. So those of us who are operators in the system have a responsibility to identify where things have gone wrong, or where things continue to go wrong, and to take necessary steps to correct them. I personally think, and I've had cause to say this in the run-up to the summit we held yesterday, that some of the reasons for the challenges in the justice sector have arisen from our history, especially, I place it at, and some people might disagree, but I think that the military interventions we've had in Nigeria's history have put the judiciary in a particularly difficult position, because the military don't they don't brook too much
process.
Yes, they're not process people. But unfortunately for us, even now we've had we can't even if that's the historical reason for the.
Are you exonerating yourselves, both?
No. Well, I'll speak to. Yes. All the actors have a role to play. The military don't operate in they didn't operate in isolation. They had civilian collaborators most of the time. So there's no doubt about that. But what I was going to lead up to was that 1999 to 2022, even if the initial cause of undermining the judiciary was military intervention, what has happened in 23 years? What we found, in my view, is that even the politicians, even our democratic leaders, have perfected the art. They're doing even a better job at undermining the judiciary than the military did. Because, if you look at the issues we tried to deal with yesterday, the starting point is the appointments process. We talk about judicial independence. Judicial independence is not an ephemeral concept. It's a mindset. So if you are appointing judges, and judges are being appointed because they have a godfather, a political godfather, then the independence is lost even before the judge first got onto the bench, because you're beholden to the person who facilitated your appointment. So that is why for us the foundation is that the appointments process must be merit-based, because that is when you have the confidence to do what your oath says, which is, without fear or favor, without whatever the other word is, or ill will, because you're there because you deserve to be there, not because somebody, put you there. And that is the way, in my view, why I say it's fundamental. That is the way in which the system has been undermined. And that is one of the reasons why the judiciary itself, and these are generalizations, of course, I'm not saying every judicial officer, but a significant number have not had the courage or the independence of mind to push back on what has resulted in where we are now. And we have to, as stakeholders in the system, we have to take steps, yes, to change this.
You know, when you talk about appointments, I tend to believe that there should be a well-structured method of appointing judges, as the case may be. But I mean, looking at it beyond appointment, when you're on that seat as a judge, you know your responsibility. You're a professional, and you have a code of conduct, and you have MBA, you have other, checks and balances in terms of performance, right? So that should play out. Now, the role of the judiciary as the bastion of a constitutional democracy, in the view of many Nigerians, has been put to test, even to an elastic limit. Because there are, let's be specific, there are issues, serious issues. Problem in the sector is not limited to just, lack of courage and, temptation of corruption. In deciding, especially political cases, this time around, the military is not here. Right, for the past 20 years or more, we have been battling with conflicting judgments and what have you. These are the specifics. I believe that the summit is also going to be specific enough to be able to attend to those burning issues. And so let us bring in another legal practitioner here with us, who was the former NBA Lokoja branch chairman, Shaba Ibrahim. Let's get your own view with respect to the summit yesterday and the dire need, to bring about reforms in the judicial sector.
Thank you very much, moderator. And let me say with mincing words that, from the start, I believe that we have collectively paid lip service to the issue of justice sector reform than being proactive in ensuring that it happens. And I say this on the platform of our three main issues. One, if you look at the system or the mode of appointment of judges, you will see that it is a process that has been anything but transparent in some cases. There are judges who have been appointed not because they really merit the appointment, but because he knows XYZ somewhere. And that brings me to the issue of the ignorant judge, with all due respect. I don't think there's anything that poses considerable danger to the judicial process than to have an ignorant judge. And in most cases, when these judges preside over issues, in order to clothe or to disguise that ignorance, they get caustic, they get irritated, they go to the extreme, browbeat lawyers and even witnesses in some cases. And I just wonder what manner of justice you want to deliver. Side by side, that is the knowledgeable judge, the one that is very, very knowledgeable, who is corrupt. I bet you, if you have a knowledgeable judge, clever judge who is corrupt, the consequence of the quality of justice is going to deliver won't be far from that of an ignorant judge. Because ultimately, justice will not be served. And I make bold to say that we have paid so much, we have concentrated so much on the issue of enforcement of law rather than delivering justice. I make bold to say that any law that does not ultimately engender justice delivery is not worth the paper upon which it is written. Another critical area, and I must say this now from experience, is the vexed issue of the independence of the judiciary. It is only in this country that you find people who walk in the rain expecting not to get wet. You have somehow kept the judiciary in hostage by not allowing them financial autonomy. Judges who are bold enough in some cases are harassed and intimidated. What manner of justice do you expect to flow from a judge who is a victim of a system where he or she is supposed to preside? So I think it's a whole naughty cocktail of woes that if we don't take time to address, and I'm glad that everybody seems to be bothered now. We have been kind enough to admit that this rot should not continue. So with due reference, deference to the learned senior advocate who thinks that, or who has opined that politicians have succeeded in rubbishing the system, I would also want to add that in addition to politicians, the legal practitioners cannot claim not to have contributed in one way or the other to corrupting this system. I think we all have sinned. We need to do self-introspection. Most of our legal practitioners apply all sorts of tricks to ensure that justice is not served when it ought to be, particularly those of the privileged class. With due respect, many of them think, I ever had an experience with a senior advocate who said, then I was a much younger lawyer. Obviously, the case was not going well against him, and he caused an adjournment. What was the reason? Yes, as a senior advocate, I cannot be seen to lose a case to a younger lawyer, so I seek an adjournment. Between you and I, that case never went on. I had to yield the floor to another person to continue when I took up some political appointment. So what am I saying here? All of us have a duty, the political class, the people in justice sector, administration, the Nigerian Bar Association. I want to commend the leadership of the NBA for taking this bull by the horn. And I hope that this, like most other attempts at reform in the past, will not be confined, that is, the reports of those conferences will not be confined to the dustbin of history. We need to encourage our judges. We need to go a bit more digital than these analog things we're doing. Many of our courts still engage in longhand recording of proceedings. You can't expect that with the growing challenges today, with the rate the world has since moved on in the direction of technology, that we can do things manually and expect to get digital results. That will not be a fair expectation.
Shabat,
I think that will suffice for the moment.
Yes, Shabat, thank you. We'll return to you in just a moment. Let's bring in now Mr. Oliver Stope of the UNODC country representative. I just want you to talk to us about, from your global prism, what you think are our realities in terms of judicial effectiveness. All I hear so far, from the learned sake, is appointments, procedure, financial, judiciary. The layman out there will think, oh, these people are still talking to themselves. They're not speaking about how a defendant, a low-income defendant, will get justice. They're not thinking about what can be done to speed up, cases in court. They're not thinking about how do we decongest the prisons. So is there a nexus between appointment procedure, financial autonomy, and an effective judicial system?
Well, first of all, thank you very much, and absolutely yes. Starting off, looking at some of the international indexes, actually the ranking of Nigeria in terms of the effectiveness and efficiency of its courts
the justice it delivers, the accessibility of the system, is declining. We had quite recently a study being published by the World Justice Project, the so-called Rule of Law Index, and on that one, Nigeria, in comparison to the previous iterations of this index, seemed to fare less well. We also had yesterday, I think, a very enlightening presentation by the Honorable Chief Justice of Nigeria in terms of some of the challenges that the system is facing, in particular in terms of clearance rates. It was quite shocking, actually, to learn that across all types of cases, the courts, both at the low end as well as at the high end, manage somewhere between 10 to maximum 20% to resolve of all incoming cases during the course of a year. So that means basically for every one case that is being resolved, there's another 5 to 9 cases that are not being resolved. And that, of course, links to all the technical issues that we have been discussing amongst ourselves. Because unfortunately, while the effects on the citizens are very clear and dramatic, I mean, you mentioned the issue of awaiting trial in prison. We have a 70% awaiting trial in the prisons in Nigeria. Amongst women, it's even worse. It's 80%. That means basically the absolute majority of people in detention are presently not even convicted so far. So maybe they shouldn't even be there. So these are obviously some very harsh realities. But nevertheless, despite the fact that there is a need for a citizen-centered, citizen-oriented judicial and justice sector reform, the solutions are often technical. And that is where the issues come in that we discussed yesterday, whether it is about delays, whether it's about the issue of judicial budget, or whether it's about the issue of judicial appointments. We, together with the Konrad Adenauer Stiftung and UNODC, have conducted a specific study on the appointment process. And there were a couple of, I think, very basic but very technical solutions to the current problems. And I think it is actually important, despite the fact that this may sound sometimes as overly technical, legalistic, sort of the ivory tower talking to itself, I think we need, nevertheless, we also have an obligation to the people out there to actually explain those things, because it has direct effects on their lives. If you can't basically rely on your contracts that you're undergoing, if you don't get protection by a judicial system, if people do not get actually arraigned in court, held to account for crimes committed, we are basically slowly declining into a lawless society. And that, of course, has effects on development, that has effects on our welfare, on our quality of life. And I think it is absolutely critical that we start to addressing those issues. And I think what was so encouraging yesterday was, I think His Excellency, the Vice President, he put it at, I feel we are on the verge of a breakthrough, which I think is really the sense that was yesterday transpiring. Because I think for the first time, you had this kind of multi-stakeholder group coming really together, and not sort of like one group inviting the other group, but really essentially everyone coming together. Of course, there were differences in opinions in terms of the solutions, no doubt, but at least there was a sort of shared sense of purpose and of urgency that some changes are required in order to improve the system. And I thought that was a very positive takeaway, at least for me. So in a sense, there is, of course, some shadow, but there's also light. And I think that's what I took away from the event of yesterday.
Okay, thank you indeed. We'll eventually, return to you. From the submission so far, I've gathered that, the low image that seems to have bedeviled the judiciary, it can easily be traceable to perhaps factors such as accusations and, of compromise and manipulation by other arms of government. But many Nigerians will be concerned about the direct activities of the bar and the bench. And as Shaba Ibrahim mentioned, he even gave an example of a case that he was involved in, where a son said, look, he cannot lose a case to a junior lawyer. But if a junior lawyer has a better perspective to the case, of course, he should be able to win. So what about the characters of the key players, you know, in this sector? Now, when we talk about cases not attended to, let me just read this. Between 2017 and to 2020, 88,170 cases were filed in federal courts and national industrial courts. Of this number, only 10,628 were dispensed of, leaving 77,542 cases pending, about just 14% between 2017 and 2020, which is about 3 years gap. So let's bring in Homabin once more here. You know, how do we ensure a holistic reform that will ensure that all aspects of judiciary, the bar, the bench, the MBA, the practitioners, the the stakeholders, and other arms of government, especially politicians? Now we are entering into an election period, you know, and of course, for some lawyers, it is time to eat. Yes.
All right, thank you very much. Let me first comment on what Shaba Ibrahim said, and I thank you for perhaps creating an anecdote or, you know, telling us of your experience. We all have a lot of experiences to share. Many of us are exasperated with the system. The question is, what do we do? And we must mean what we say and say what we do. So what he said about senior advocates is absolutely right. We're also looking inwards. I think the current MBA, as yesterday he made the president of the MBA made the point clearly that there will be need to look at the structures, and some of it are inhibiting at the moment, on how we discipline lawyers. And I think for some of us, even at the senior level, we're beginning to think about how we discipline ourselves, because if we don't do it, the public will do it. So, but what we want to focus on is move away from identifying the problems. And I think the problems are well known. There's a lack of confidence. What do we do going forward? It's not rocket science. Lagos State did it before under the leadership of the now Vice President, who was Attorney General. He looked at the whole government, including the police. In fact, I recall, because I did some work for them during that period, that Lagos State decided to assist the police in purchasing some materials, papers, cars to move prison officers. Now, what we have done with JRP is to say, look, we need to do more virtual hearings. So if you had, for example, the possibility of a judge sitting, and in the prisons, you could actually interact with the prisoners, quick overnight cases, and then you're having sittings maybe morning, afternoon, and evening, you can decongest the prisons almost overnight. You don't need, it's not rocket science. Look, the solutions to many of these problems are clear. The mindsets and the orientation of those who perhaps occupy sensitive positions is what we need to concentrate on. In other words, character. So when we say, in order for you to practice law, you have to be a fit and proper person, those are heavy words. What does it mean? It means you demonstrate scholarship in learning, you demonstrate scholarship in your character, scholarship all the way to say you're a fit and proper person. My father is a bit more acerbic than I am. He used to say that law is not for everybody. It's a calling. And therefore, there are certain traits and characteristics that you must exhibit. Now, what we have is you've had all types of people come into the practice of law, and then you have a few of those characters elevated to the bench because there's no system. The system is opaque. There's no transparent system of elevating those who are of character to the bench. And then they begin to move from the courts of record, the high courts of records, you go to the Court of Appeal, and then possibly to the Supreme Court. When you have somebody who is not of character in the Supreme Court, it's a disaster. So let's concentrate on the system by which you elevate people, both as senior advocates. And I think there's always a criticism when we speak in public. I'm a senior advocate, and people think everyone who is a senior advocate must have been involved in some process that was untoward to become a senior advocate. That is not entirely correct. And there are people who've done very well in the system. The process of actually elevating people to the senior advocate is also under question just as much as the process of elevating people to the bench. This question of yesterday, there was a question which was asked, and you have very good people who are practicing, who are senior advocates, you have very good, talented people practicing, who are sitting over cases. But we don't want a situation where you get the best and by accidents. We want a process where you elevate people because the system is structured, is transparent, and then you build confidence. Yesterday, we divided the seminar into 3 parts: delay, budget and financing, appointment and selection, and discipline of judges. Now, the place is critical to this, but the problems are so immense that you need to start from a perspective that is under your control. Just remember that all these groups that came together, the very first time you had the NJC, you had the judges, the former polarization that you had between the bench and the bar. We want to collapse that because there's been a lot of accusing fingers. Oh, it's the bar that's causing the problem, it's the bench. I think yesterday, for the first time, we all found that everybody wants reforms. The question is really just tinkering within few of the recommendations. And what is unique about this particular summit is that I think the president of the bar has made it clear he's going to set up a group of people who will not only implement, who will evaluate the process, and then there's a schedule. Within a certain time, we're going to achieve.
What do you hope to achieve? You just talked about collapsing the bar and the bench. What's the goal?
Well, the dichotomy used to be that once you identify a problem, the bar will accuse the judges of not exhibiting whatever it takes to adjudicate over a process. The bench will accuse the bar. The problem is the problem of all stakeholders. So that's what we achieved yesterday, conceptualization, just bringing everybody together to say this is all our problem. It's not a question of pointing fingers, and we have to do something about it.
Will that address the issue of conflicting judgments and the integrity or quality of the judgments that are given?
Definitely, because what you will have is you have people of integrity, people who are demonstrating scholarship and learning. Why do you have conflicting judgments? Because sometimes the judges are so overburdened, they don't have an opportunity to read all the cases that are related to that particular area. Indeed, look, I recently had to give expert evidence in the UK, and I've done that a couple of times. The level of detail that you have to attend to is nothing compared to what you have to do here, because the judges are overburdened. Indeed, the number of cases before many of these judges, you cannot administer, you cannot dispense justice under those circumstances. If you go to the Supreme Court, which is a court of policy, you are now required to adopt your brief. You're not required to expatiate. And even in adopting your brief, the concentration is on procedural justice. So you have a situation where the client is sitting behind and saying, no, that is not, they haven't decided my case. If you have to decide a case on a very small technical point, maybe because a lawyer did not sign properly. But indeed, the judges are trying to clear their dockets because there are thousands of cases. So 2 things you have to do. First of all, you look at the back end. And then you look at the integrity and the intelligence of the judges who are sitting there, because you need a very high intellect to sit at that level. So the process of appointment is key. So what we did yesterday is to say, look, just as much as you have lawyers who are perhaps not fit for a purpose, so also from that group you've elevated to the bench. How do we deal with this problem? As Oliver said, there are technical solutions. There's no quick fix, but there are some things we can begin to do almost immediately.
I think we'll just allow you to take a breather and bring in Dr. Babatunde Ajibade. We're trying to cleanse the system, and he's just talked about the need to have, people who are fit, in the justice sector, to be in the justice sector. Now, if you collapse the bar and the bench, and already we are talking about some people that are not supposed to be there, how will that impact on the quality of our justice dispensation?
I think the point Mr. Hobame was making, which is a very important one, is that before now, we've failed to see the problems of the justice sector as a common problem. And it's some form of escapism, as far as I'm concerned. Let's pick on delay, for example, which, as you said, is a critical. I listened to we all listened to the CGN yesterday reel out the statistics about the disposal rates. So before now, you speak to your average judge. Oh, why are cases not moving? It's those lawyers. They're terrible people. They come with all sorts of objections. They waste the time of the court, etc. You talk to your typical lawyer. What's the cause of the delay? The judges, they never sit. You go to the court is not sitting, or the judge will not take my case. You know, so we spent a lot of buck passing, precisely. We spent a lot of time, you know, throwing darts at each other. But as far as I'm concerned, and as far as the NBA is now concerned, this is not about whose fault. We're supposed to be providing a service, and it's a critical service to society. So the litigant doesn't really care whether it was the judge's fault or the lawyer's fault. All the litigant knows is my case has not progressed, or the accused person who is in prison, who is entitled to bail, but his bail application cannot be taken. All he knows is that he remains incarcerated. So we need to stop the buck passing and work together, the bar and the bench and civil society, to ensure that this system works for the benefit of society. So that is the point Mr. Ehobame has made, that yesterday, for the first time in a long time, you actually had the profession working together rather than pointing fingers at each other. We're now saying, you know what, this is getting out of hand. We need to work together to address the problems. Identify them, we know what the problems are, identify solutions, and start implementing those solutions.
And now, talking about implementation, that is the crux of the matter. It is good that both the bar and the bench have been able to identify what the problems are. You have just enumerated that Mr. Ehobame also did, as well as Shaba Ibrahim did. But the point is, what are the mechanics, you know, of providing a preferring solution to this? What should be the role of NJC and NBA in all of this? And I want to bring in Shaba Ibrahim once more. As problems have been identified, it's no longer buck passing. We know where the problems are. What is the technical way that this can be approached to ensure that it does not continue? Because after the summit, and you know, and the challenge persists, then it does appear that the summit would have been just a mere, you know, conference, you know, that will not, you know, impact on the judiciary.
Well, thank you very much. My view on this is that of all considerations for appointment of judges, the one that I think is most paramount is, because the issue of fit and proper are based on qualification, academic qualification, and perhaps the industry you're able to put in, all academics, fit and proper. You're able to pass your courses in the law school, you are fit and proper. But I think we need to take a detour and look at the moral and character content of our nominees. Anybody who is to be saddled with the duty of determining the rights and fate of other human beings must be people of impeccable character. I say this because I have seen some very dreadful situations where, for instance, I'm going to spare you the details, but I've seen a situation where a magistrate who was accused and even arraigned before the court of sleaze and all sorts of things found himself on the bench, a high court bench. I recall that I had to put a call through to the chair of that branch of the NBA because somehow we evolved a system whereby the NBA has an input as to who is fit and proper, character-wise. And to my surprise, the chairman then replied that, yes, they cleared everybody who was proposed. And I said, what about this particular nominee? And he said, he doesn't want anybody's trouble. They decided to clear everybody. That kind of mentality must change. If you are bad, you are bad. And with due respect, it's not about buck passing. We must situate the blame at the doorstep of the transgressors. If we don't do that, how do you now punish everyone? We can't generalize. If the legal profession is not doing its best, we should point it out and situate the blame right at that doorstep. I'll give you an instance. The legal profession has, I have participated in prosecuting cases at the Legal Practitioner Disciplinary Committee, and I discovered that some appeals came up that brought almost a total halt to our proceedings on some technical grounds that I personally am able to appreciate till this moment. Ditto for some other cases like that. Let us be brutally frank with each other. If we want to move forward, we must take a break. We must take a break away from this technical justice we're handing out and doing the right thing. If those who don't ought to be on the bench are not there, then there can be hope. But if you have to, because character is static, character remains. Nobody changes his character at the age of 40, 50. You're already molded. So if a man is not doing well, if you profile him and you discover this man has innate tendency to be corrupt or can be easily swayed by sentiment, he is not a fit and proper person in my humble estimation. So I want to go back to that issue of character, and side by side that administration of justice, you have to talk about the prison reforms. I recall that more than over a decade ago, during the regime of, when we had Chief Bayo JSN as Attorney General, I think he did introduce something, prison discongestion. I was a beneficiary of those, that effort, wherein we were expected to go around the prisons, collate people who had no, there are some cases that have no business even going to court. You find people who, at the office of the Attorney General, you need to profile a lot of cases before you, people who should just be maybe cautioned and allowed to go are sent to prison. They get radicalized in prison and now unleashed on the society thereafter. These people come out with their grudges and partake in more crimes as if it's payback to the society. So I think we need to take a look at all these things. You cannot have a justice system where a judge will be ready, the lawyers are ready, the prisons officials don't have a serviceable vehicle to bring the accused persons to court. So all these things are interwoven. And like I did say, I'm glad that at least for once we have admitted that all isn't well. It is from that reality we're able to fashion out an acceptable solution so that for once we can continue to move forward. I'm not advocating jet speed proceeding.
You see, the part of the question that I asked actually had to do with remediation. How do we begin to tackle this issue? Yeah, it has been raised. All the sons here have virtually raised the key issues here, the challenges, the problems, bedeviling the sector. Now, how do we begin to profile solution? What is the methodology? What is the role of MBA, NJC? How can these persons who have found themselves in positions they shouldn't be because of character, how can they be fished out? How can they be deroped if necessary? Because if this is not done, the cleansing that you are trying to embark upon may not yield any fruit. And let's
yes, I think Honorable Shaba will just keep that with you. We'll return to you to take those questions. I think what Kiran is trying to find out is what is the way forward? How do you begin to implement the outcome of the summit? And I would like to put that question also to the Senior Advocate Ehubamie, just before you go. Tell us, what now, after the summit, what next? And what would you like to see changed in the appointment procedure, since that is a fundamental issue?
Okay, thank you very much. And that was the benefit of the summit yesterday. Some clear recommendations were made. But let me say that, Honorable Shaba Ibrahim, thank you. You identify all the problems, and these problems have been there. I am very critical of many of us who've identified the problems, because I say, what have you done about it? My late father, took up, he was practicing lawyer and then became a senior advocate. I remember as a young lawyer, took up a judge who had issued a FIFE on the wrong circumstances. And he took it all the way to the NJC, and that judge was removed in Benin. Now, so many of us speak a lot about these issues, but we need to do something. Each of us have to volunteer ourselves to make this change. Now, yesterday, a few recommendations were made. One is to demarcate or differentiate between the administration of justice and the administration and management of the court system. So let me give you an example of what I mean. A chief judge has no business signing contracts to buy newspapers or deciding how resources should be allocated, whether you build a court or you are sending judges to training. That should be done by professionals who are trained in that field, so that you leave the judges to adjudicate. And therefore, you know the enormity of the work. If you're going to be a chief judge, it's a lot of work, not so much in terms of administration, but how you dispense justice, how you look into the issues of reform. I always say that the way in which our law students should be trained is that every practitioner who's worth any success to his name must know the law, know what is wrong with the law, predict change, and participate in that change. We're all part of the problem, and so we must all be part of resolving it. Another issue that we perhaps didn't discuss much yesterday was virtual hearing. Virtual hearing, in other words, hearing on Zoom platform or whatever it is, will reduce the delay considerably. But unfortunately, the mindset of many of the old guards in the system, lawyers and practicing lawyers and judges, is such that people just refuse to accept it. So I'll give you a typical example. The Justice Reform Project went to court to argue that in the appointment of judges, the last but one, I think, that the NJC itself, again, this is another point. You asked me what should be done about appointments, discipline, and selection of judges. The NJC is the body that superintends over this process. The constitution of that body, the way it is structured, does not perhaps enable effective selection because there's so much power concentrated on the chief judge. But the chief judge himself has said 2-3 years ago, look, I didn't make the constitution, I don't make the rules. Even the policy, whatever is needed to be done, let's change it. Now, practitioners were part of that summit, and again, nothing was done. So what we're saying is, let's stop passing the buck. Let's all come together and let's effectively implement whatever is discussed. And that's why I'm very happy with the current Embry leadership, because what Oluwapata has said is that, look, having discussed, I now need to go into enforcement. In other words, set up almost a task force, and then we have a schedule and we have a process of evaluating performance of that implementation. That's what we're doing. Thank you.
Okay. At this point, we would like to appreciate your contribution this morning on the program. We learned that you have another appointment elsewhere, and we'll thank you indeed for coming this morning. We hope to bring you back some other time when we have such a critical legal matters for conversation on Good Morning Nigeria.
Indeed, Kiran, just to say that it was a sterling contribution from Senior Advocate of Nigeria, Osaro Ehubami. We appreciate you, sir.
Just before I go, I always say to everyone to show and demonstrate the sacrifice that we need. I am running a 42-kilometer race. And I'm asking all the editors, because the reporters are also important in this. How you report the cases sometimes is something that worry a lot of us. So we need training of not just the registrar, but all the ancillary services that are necessary in the administration.
Okay. All right. Thank you. That's a topic for another day. And at this point, we will take a short break. When we return, the conversation continues. Stay with us. Yeah. All right, you're welcome back. This is still Good Morning Nigeria on the network service of NTA. We're going back to Shaba Ibrahim. Now let's begin to talk about solutions and implementation strategies. How can it work? We have two very prominent bodies when it comes to the judicial sector. MBA, that's Nigerian Bar Association, and NJC, which is also a very well-structured body. What are the roles of these two bodies with respect to implementation strategy? of course, which is one of the takeaways from the summit yesterday.
Thank you. Let me say that apart from addressing the issue of the opacity or the blood nature of, or the lack of transparency inherent in the process of appointment of judges, you have to strengthen the discipline regime. You see, people get away with a lot of things where there are no consequences. If you, no matter how strong the laws are worded, if they are not implemented, it approximates to nothing. So I want to see a judiciary that will come down heavily on erring members whenever it happens. I want to see the judiciary that will come down heavily on legal practitioners whenever they cause any infraction that will impact negatively on the administration of justice. I want to see the executive realize that there are three arms of government, and the head of the executive is what I call primus inter pares. There is not a master-slave or master-servant relationship where the judiciary will have to go cap in hand at every point in time. You find scenarios where judges, they become timid naturally because he who pays the piper dictates the tune. Many judges cannot dispense even-handed justice because they fear of the backlash, the consequence from a government that does not seem to have tolerance for adverse views as far as the administration of justice is concerned. So if we change if we'll change our mindset and agree that all these regimes need to be set, for once, let us put an end to this vexed issue of independence of the judiciary. There is no form of independence that is as important as financial autonomy for the judiciary. Let us begin from there. And I mean full independence, not the type that are granted, I mean, on the pages of newspaper, and in implementation you don't see it. And let me also advise, the judiciary itself can whip erring people into line by being bold enough to say it as it is. I believe that if you take one or two hostages, quote and unquote, if you really show that you have the power not only to back, but you can bite, I think a lot of things will fall in line. So having said this, I think the last is an appeal to our conscience, appeal to our morals, that if you find yourself in a position of power, influence, or authority today, you're not going to remain there forever. Know that if you leave a legacy of a rotten and, a terrible system, you could become a victim of that system tomorrow. If the prisons are not reformed, those in public offices, those outside it, are all potential visitors to those facilities. If you treat those facilities well, when it's your turn to be there, you enjoy the benefit of what you have done. But if you refuse, we all will be imperiled. That is all I have to say for now. Thank you so much for granting.
All right, thank you, Honorable Shaba Ibrahim, for your contribution. Let's bring in now Mr. Oliver Stope. We've been talking about, reforms in the judicial system, and indeed, it's just like when you compare, the judicial system in Nigeria and the people, it's like water and oil. I mean, each is, to itself. There's no confidence. I'm wondering if this summit really looked at how to restore, confidence in the citizens. Because a lot of people still believe that their rights, are trampled upon. They have no rights in the judicial system. They are extorted. They are embarrassed and all that. So, how will this summit address those issues that really affect true justice dispensation to the ordinary man?
Right. Well, certainly rebuilding confidence is not an easy task, and I think we took an important step yesterday, but certainly it's just the first step on a very, very long journey. And we are all collectively responsible for the outcome of that journey. that sense of urgency that many of the speakers yesterday called upon, both from inside, from the bench as well as from the bar side, is true. It's an acknowledgement exactly of the issue that you're raising. But I'm equally, well, skeptical is too strong, but certainly I'm demanding in terms of actual follow-up action. Because it is very true, we have been conducting these kind of events for many, many years. I've been first involved in justice sector reform in Nigeria 20 years ago. Well, but in fairness, justice sector reform is not something you start and you end. It's an ongoing process. A country like Nigeria, with its development aspirations, with its growing economy, with its growing population, will constantly have to evolve its institutions, including the judiciary. When I first came to Nigeria, there were 140 million Nigerians. Now we're more than 200 million. How do we provide the services for this massive amount of people that have economic aspirations, that will have legal challenges, that will get in conflict with the law? They need to be provided by that system, and the system needs to grow and needs to become more efficient over time. So it's not a process you start at some point and then you say we have concluded, but it is a continuing process.
But it's not a process that lasts forever. If the first time you were part of a summit like this is 20 years, and we are still talking about decay, rot in the system. So are you still optimistic that this summit is revolutionary or will be revolutionary?
Well, as a development practitioner, to some extent, optimism is a requirement for the job. But to be more serious in answering your question, yes, I remain optimistic. I remain cautiously optimistic, but I remain optimistic for two reasons. One is I have seen actually between 2000 and 2010 some very significant improvements in the justice delivery. We measured actually, for example, the readiness of people to go back to court after they had actually a case was increasing. The average time it took for a case to resolve was reducing, both in criminal cases as well as in civil cases. So there were improvements under the leadership of a variety of Chief Justices of Nigeria, but of course then also very importantly implemented at state level by the Chief Judges, by the State Attorney Generals, and of course often with the support, strong support of the respective governors, especially where the governors actually respected the independence, but also empowered financially and otherwise the judiciary to implement certain reforms. I think Lagos State remains always, in many regards, a very positive example. So I think we collectively have to prove. I'm somehow encouraged the next actually consultation of the organizers of the summit will happen within 24 hours from now. So we are obviously taking it seriously. We will also, you mentioned the National Judicial Council. That is a critical partner we need to bring fully into the boat, not just occasionally when there's a big conference, but as part of the working group to implement some of the recommendations that came out. And then, of course, it's little steps. I mean, at the end of the day, I think one ambition of the summit was, let's come up with practical proposals that can be actually implemented. Let's not pretend and claim that we can change a system with all its challenges overnight. And that we can even come up with good and solid proposals in the course of one day in order to fix all the ailings of the system. But let's identify some of those things, let's do them, and then let's gather also strength and support for reforms, because hopefully those reforms will actually translate into visible, tangible results for those that come to the courts in terms of seeing actually that things are working better. And I've seen that 10 years ago, as I said, happening, and I'm very sure we can repeat that It just takes a sort of like shared sense of enhanced responsibility and urgency for these results.
No, all right, thank you. Let's go over again to Dr. Babatunde Ajibade. The summit had the theme, devising practical solutions towards improving performance, enhanced accountability and independence in the justice sector. Now we are looking at solutions, right, and the practicability of implementing strategic, decisions taken at the summit. Which way forward with respect to ensuring that airing both members of the bar and bench can be tracked, traced, and of course disciplined. We saw what happened, the build-up of Anambra State election, how we have incidences of conflicting judgments that led to the invitation of about 3 or 4 judges, by the Chief Justice of Nigeria. And of course, Nigerians hailed him for what he did, because we didn't see the reason why 3 or 4 judges would be, giving judgment on a particular case, in a situation that even made Nigerians believe that these judges were not serious-minded as far as their profession is concerned. So, which way going forward?
Thank you very much. So, starting from where you ended, the question has been asked, and it's a very legitimate question, that as far as the incident relating to conflicting court judgments in political matters is concerned, the judiciary has taken a step by sanctioning some of the judges involved, and what is the bar doing? And the NBA has also taken steps. The NBA president set up a committee, which I was asked to chair, and we've submitted a report identifying the lawyers that were involved in those cases. And the NBA is currently putting papers together to file petitions before the Legal Practitioners Disciplinary Committee against those lawyers. So you will hear, I'm sure there'll be more news about that in the next couple of weeks. But that is just a very specific and very narrow aspect of the problem. In the context of what we did yesterday, that is not even, as far as I'm concerned, it's just a speck. But as we have said, I also, of course, one must be cautiously optimistic in this environment, but I think that the summit yesterday was different. It was different because we set out to identify practical solutions. And I think we came away with some significant wins. Significant because there was consensus around them. So it wasn't a us against them kind of solution. So, for example, take the issue of appointments. And I think off the top of my head, we're still developing our communique, which will be made public, hopefully before the end of today. But off the top of my head, I can identify maybe 4 or 5 quick wins. On the issue of appointments, we have a process now presently where how a person becomes a judge, there's no consistency. You have some states where before you can become a judge, you have to go through a proficiency test of some sort. But it's not mandated by the current guidelines for the appointment of judicial officers. So we built a consensus yesterday around that. Even the judges, justices of the Supreme Court, chief judges that were present, there seems to be an agreement now that we should standardize this. Because there are too many instances where you have, Mr. Honorable Shaba Ibrahim made the point. We complain about corruption, we complain about incompetence. The debate may be out as to which is worse. But then you have, what about where you even have a combination of the two? So you have to make sure that the quality of judicial appointments is the best it can be. We conducted a poll yesterday, asked all those who were in attendance and even those who were attending virtually. We listed 5 characteristics of a judicial officer. And there was an absolute majority that the most important thing, apart from knowledge of the law, is your character and your reputation. Because if you're not, again, as Honorable Shaba Ibrahim said, if you were a sleazy lawyer, there's no way you're going to become a judge and suddenly transmute and become a decent judge. So we need to The bar also has to play a role in ensuring that it is only the right people that get through that filtering process to get onto the bench.
We have to.
Okay.
Should there be a periodic evaluation mechanism in all the courts to be able to begin to track, erring practitioners?
That may well be, but that is not for us. Where we want to start from is at least let's stop the rot. No, you're talking about people who are already in the system, who are already judges, and how to fish them out and take those out of the system. Yes. I hear you. It is
and even the lawyers as well.
And lawyers, yes. It is a significant concern. We need to strengthen the disciplinary process at the bar and the bench. But for us, as a starting point, because we acknowledge that we can't solve all the problems at once, if we're still struggling with exactly how to fish out or make the process, because there is a process. I mean, there's a disciplinary process both at the bar and the bench. The NJC takes care of the bench. The LPDC is supposed to take care of the bar. Those processes are not working as efficiently as we would like. But let us not add to that problem. Because say, for example, you have a pool of 1,000 judges, and I'm just picking a number. Now, if you're adding 100 judges to them every time, let's assume that out of that 1,000, 500 are bad. If the next time you're going to add 100, you make sure that the 100 are all good, then your percentages are starting to improve over time. You're diluting the problem. So we want to start at that point. That, look, yes, we will find a way. We'll try and improve the system of taking out the bad eggs. But let's make sure we don't add more bad eggs to the basket.
Yeah, Dr. Ajibade, quickly, we have just 2 minutes to wind down our conversation.
Can I hit a few?
Yes,
because a few more of the.
Yes, take this with you. Mr. Stoke expressed the hope that within the next 24 hours something should happen as a step forward. Yes. What is likely to happen?
Okay, so what is going to happen is that the organizing committee, we've been working together on this for, and it's been plenty of sleepless nights, I can assure you, between Oliver and I. And one of the things, typically, and I say this without any fear of contradiction, and again, this is the difference. Typically, you'd hold this kind of summit or conference, and that is it. Everybody breathes a sigh of relief, oh, it's over, now I can go back to my day job. But on this occasion, we've agreed that, even before the summit, we had agreed that the hard work actually starts after the summit. So we're holding a meeting tomorrow, the same group of people, the same organizing committee, to say, now, this is what we've done. These are the things that came out of the summit. Now we have to develop a roadmap for implementation, carrying all the stakeholders along, the NJC, the Honorable Attorney General of the Federation, the Nigerian Bar Association, civil society, Access to Justice, the United Nations Office for Drugs and Crime. We're all galvanized to ensure that this is not just another talk shop, but that we're actually going to take this forward. And more importantly, this is going to be an annual, we've also resolved that it's going to be an annual event. So we're going to have another summit, hopefully about the same time next year, where we're going to track progress and say, these are the things that were agreed.
Look at implementation of contents of the roadmap.
Exactly.
Okay, Kiran.
Exactly.
Okay, well, it is said that we are going to conclude today's conversation on Good Morning Nigeria. Of course, robustly discussed this issue. But as it were, we might reconvene on this platform and again bring in an issue concerning judicial matters in Nigeria. As the guest rightly pointed out, of course, it's not something that can be solved in a day. It's a step that has been taken, and we expect to have more steps to ensure that the sector is actually properly reformed or stabilized. All right. At this point, I would like to appreciate Dr. Babatunde Ajibade, SAN. We thank you for your contribution this morning.
Thank you very much.
All right. And we hope to see you again some other time. And let's also appreciate Mr. Oliver Stope, the UN Office on Drug and Crime. Thank you indeed. And, of course, Honorable Shaba Ibrahim, Member, House of Representatives, and former Chairman, NBA Lokoja Branch. We thank you indeed for being part of our program this morning.